to Riley's point there on the different constitutions, we got to understand where we were, almost 250 years ago. We were 13 colonies, which were 13 individual nation states. And they each had their own constitution. So yes, there are multiple constitutions because each individual state had one. They coalitioned to form a United States in the federal government, giving limited authority, limited jurisdiction of powers, and laying that out in the U.S. Constitution. And it also retained many of those powers, what's not given in the U.S. federal Constitution, the states retained or the people retained them. So it's very specific on what power was given, and everything else is retained, and it's non-exhaustive as far as what those rights are.
Well, I think that's a big thing that people don't understand. And I'm curious too, having not taken the class, do they refer at all to the fact that law schools now don't teach the Constitution? They teach case law. So we're not even doing what the founders wanted us to do, which was to take these laws, go read the Constitution, say, okay, well, I know this doesn't fit in under number 3, so we can't do that one, right? It doesn't work that way anymore. They say case law. And for those who don't know, what case law is, it's I've taken a case to court. The judge made a ruling, and now we're taking the judge's ruling to decide the next case, not the Constitution. That's where we are right now.
Yeah, I think an easy example of that is used in the class is talking about the separation of church and state. Most law schools they address it, and the students, actually many Americans still believe that separation of church and state is in the Constitution, and it is nowhere in the Constitution.